Okay, over to you.
I think that was to me.
Yes,
You cut
sorry.
out there,
Yes.
sir.
Yes, Mr. Michael Salad, it's over to you.
Okay, great. Yeah, unfortunately, when you froze on us there for the last 30 seconds, but
Oh
you,
no. Oh, sorry.
no problem. No problem. I echo a lot of what you just said there. My son, Josh, my name's Michael Salad. My son, Joshua, has Bainbridge-Roper syndrome. He's 8 years of age. I've been on the board of our foundation for a little over 3 years, and he is a member of a bunch of these items that Sarah was kind enough to point out and would encourage everybody to join as well. I appreciate everybody hopping on late this evening on the East Coast. I very much enjoy giving these presentations. It's my way of being able to uh, make a small, do a small part here in helping out families with similar situations. I was explaining and somewhat joking with Sarah before we began that we, as parents of those children with disabilities, don't have the luxury of postponing our planning like many other families do that have typical children, and they can run the risk a little bit more than parents with children with disabilities can run the risk of passing away and not having proper planning in place. We really can't do that. I like to start these presentations when I'm talking to a broad audience of people that are not only potentially throughout the country, but throughout the world to keep things relatively broad, as opposed to when I give a presentation to people who are all in the same jurisdiction and I can focus on specific state laws. I like to keep these presentations relatively broad. If questions arise, those that are participating on Zoom are welcome to stop me or place any questions into the chat. And those that are hearing this on a recording can certainly reach out. And I'm always more than happy to be a resource to try to find you the right counsel in the jurisdiction in which you are located and answer some questions as they arise. I'm going to start off with the core documents that everybody needs, and that starts with a last will and testament. Everybody needs that, whether you have a child with disabilities or you do not. If you own anything, whether it could be as simple as a basic bank account or personal possessions, you need to have a will. In addition, you need to have a power of attorney, which comes in different flavors depending on the state or jurisdiction that you reside in. Sometimes they can be what's called a general durable power of attorney, which means it becomes effective immediately. Other states allow for a springing power of attorney, in which it springs into effect upon your incapacity. So all parents need to have those two documents in place. The third document is a living will, also known as an advanced healthcare directive or a healthcare power of attorney. In many states, the living will allows you to outline what your wishes are if you're in a persistent vegetative state with no reasonable chance of survival. And it is usually accompanied by a healthcare power of attorney or a similar document to that in which you nominate someone as your medical proxy to carry out the wishes that you have designated in your living will. So basically, everybody will need those core documents. Living will take care of the healthcare decisions. Your general durable power of attorney takes care of your financial decisions during your lifetime. And then the will address the disposition of your assets after you have passed away. For those that have any beneficiaries with disabilities, we also need to address a special needs trust. There are several different types, but for those that are setting those up as parents of children with disabilities, it is likely what's going to be called a third-party special needs trust. That means you, as a third party, are setting it up for somebody else. This can be established as a standalone document. So you may set up your own special needs trust, and it is a separate document. And at the very top of it, it will say special needs trust, and you can outline the beneficiaries and the trustees, which we're going to discuss in a moment. In addition, it can be included in a will. When you include a special needs trust in a will, it's called a testamentary trust. So when you pass away, if you are leaving assets to a beneficiary with special needs, you generally will include special needs trust provisions within your will. A third alternative is a revocable trust. Many states, I'm licensed in several, too many, the standard practice for estate planning is to have a separate revocable trust as part of your core estate plan. So probate may be very difficult in the jurisdiction in which you reside. Probate is the process that your executor or representative or administrator goes through after you've passed away. Some states, like my former home state of New Jersey, that process is very, very easy. In my current state of residence, Florida, it is known to be an extremely difficult process. So the estate planning process, when you're putting together these documents, usually includes a revocable trust in my home state of Florida, whereas it doesn't always include a revocable trust in New Jersey and other states. If you have a revocable trust or you're setting that up as part of your estate plan, you can also include a special needs trust within your revocable trust. The benefit of establishing a standalone special needs trust is that you can establish it and fund it during your lifetime, a whole lot easier than you can in a revocable trust. And you can't use a testamentary trust to fund a special needs trust during your lifetime because that trust only becomes effective when you pass away. So taking it one by one in terms of regardless of the type of special needs trust that you set up, whether it's a standalone trust, in a revocable trust, or a testamentary trust, there are three components to it. You will have the grantor, the trustee, and the beneficiary. The grantor is the person who sets it up. So if you as the parent are setting up this trust for a beneficiary with special needs, you will be the grantor. The trustee is the person who is responsible for administering the trust. That person makes decisions about how the funds are invested, how to distribute the assets, what assets are going to be in the trust, and what assets will be going out of the trust. The third component is the beneficiary. This is the individual or individuals who are going to derive the benefit from the trust. In addition to the third-party special needs trust, we have a first-party special needs trust, which means the person with a disability is setting it up. This would occur if a person with a disability is earning income. Perhaps they have a job and they are earning some income from that job. And now they are concerned that the income that they are earning will cause them to become ineligible for government benefits. This could be Medicaid, could be SSDI, SSI, variety of other state, local, and federal government benefits that are based upon your assets. In those instances, we want the child with disabilities, the person with disabilities, to place these assets into a first-party special needs trust. In other instances, they may have received an inheritance, and now they need to place the funds into the first-party special needs trust. In many other instances, they may have had some type of lawsuit, maybe a medical malpractice issue caused the disability. Maybe there was some other accident that occurred and they are now receiving a lot of money at once. A first-party special needs trust may be established. The third type of trust is a pooled trust. It's a little bit less common, but generally you use a pooled trust if you want to have all of the administrative aspects avoided. Sarah, was that a question that just popped up or no? You're muted.
Just had someone join. We're all good, Mike.
Okay. Let me know if questions arise because I'm not necessarily looking at the chat or anything else consistently. With a pooled trust, there is what's called this master agreement. So you don't have to set up your own special needs trust. you have this pooled trust master agreement that is already set up, and then you sign a joinder to that agreement. And there's one main account of all of these pooled assets. And then there are sub-accounts that are created for each individual beneficiary. When that is set up, you are able to avoid a lot of the need to meet with folks like me and set up a standalone trust. You may still need an attorney to help you out and point you in the right direction, but you don't have to have this separate trust. They are nonprofits that operate a pooled trust, and they generally have a lot of resources. They have a lot of literature and other key contacts with other agencies that can help streamline processes and finding certain resources, perhaps group housing, those types of things. And after a person with a disability passes away, generally, part of the assets that are still in that trust, if there are any, may go to the nonprofit to keep it operational. And also, in certain instances, it will be used to pay back the government for benefits that were provided to the individual with special needs. That is also a key difference between a first-party special needs trust and a third-party special needs trust. As I mentioned, the first-party special needs trust is established by or on behalf of the individual with special needs. The third-party special needs trust is established by somebody else for the person with special needs. In a third-party special needs trust, when the beneficiary, the person with the disability, passes away, there is no need to pay back the government or any other third parties that may have provided benefits to the person with special needs. Whereas with a first-party special needs trust, when that person with the special needs passes away, first, you need to pay back any government agencies and third parties that may have provided benefits. And then only after all of those third parties have been paid will we be able to distribute funds to any remainder beneficiaries. So if my son Josh sets up a first-party special needs trust tomorrow, let's say he's earning income at a job. He's only 8, there's labor laws, I understand that, but just for hypotheticals here, let's say he goes and takes a job tomorrow and he's earning income and he wants to place the funds into this first-party special needs trust to receive government benefits that he may have been already receiving. In that instance, he now could set up this trust, or I could assist him as his guardian to set up that trust. And then we would nominate a trustee. Let's say I would be the trustee. He could be the beneficiary during his lifetime, but any funds that remain in that first party trust that he had contributed during his lifetime need to first be paid back to any of those government agencies, such as Medicaid, after he has passed away. And then only after those third parties have been paid back will he be able to dictate who would receive the remaining funds. So let's say he left the rest to his sister. She would only be able to receive those funds after all of the other government agencies received their payback. If I set up a third-party special needs trust for Josh's benefit during his lifetime, then after he passes away, the beneficiaries that I've nominated, let's say I nominate his sister, my daughter, as the remainder beneficiary, immediately upon Josh passing away, everything would then pass to my daughter and not to any third-party government agencies, because I had contributed the funds as opposed to a first party where Josh had. Does anybody have any questions on that?
So I had a question.
Sure,
Just
Sarah.
to clarify, okay, so in my very limited understanding of this, if we chose to do a third party so that if Sammy were to pass, everything could go to whoever we chose. If Sammy were to have a job and we had the third party trust, any of his income would count towards, like, income that he's getting in, and it would have to be under a certain amount, right? Or else it could affect like him receiving disability or okay.
So
Okay.
you would want to assist Sammy in this example in setting up a first party special needs trust. And you need to have separate accounts. It's very important. You would have one bank account under the name of the first party special needs trust that Sammy has set up. And then you have a separate one for the third party special needs trust that you set up for his benefit.
Okay, so it can be, you can have both kinds.
You can.
You don't have to choose one or the other.
That's-
Okay. Okay,
Yep.
that makes sense.
Yep. And that's a very good question. And it's important. And the real key is to make sure that you have separate bank accounts set up and that they're not commingled, those two trusts. Another very important consideration is guardianship. And this feeds into the trust in a limited manner. In guardianship proceedings, sometimes they're called conservatorships. In most states, a conservatorship applies to guardianship, but it's over the person's property. Whereas the guardianship is a control over the person, helping them day to day in terms of making sure they have a roof over their head, making sure that they're going to school if they're minors, making sure that they have clothing, making sure that they're going to doctor's appointments, taking them and all of that. So you can have a guardianship in some states of the person and of the property. And then in other states, they would call guardianship just over the person and conservatorship over the property. But those two terms are, in most of the states that I'm aware of, usually the phrases to look out for. And it is very, very important that you address a guardianship issue if you have a child with disabilities. The first aspect is what happens if the child is under 18 years of age, they're a minor. You want to have in your own will or trust very specific guidelines as to who will become guardian of the person and property or conservator in other states of that child while you are a minor. In instances in which a spouse is alive, general, or even the parent, they don't have to be a spouse, but the parent of that child with disabilities, there is a presumption in almost every state that that other parent will become the guardian. So the key question will become what happens if both parents are to prematurely pass away while the child with disabilities is under 18 years of age. That's usually the age for being a minor. Some states have 19 or 21, but most states use 18. So you want to outline who will become the guardian of the person as well as the property of that individual. It doesn't have to be the same person. You could nominate one person as guardian of the person and another as guardian of the property. But most commonly, you will nominate one person as guardian of the person and property because you usually have somebody else who is the trustee of the trust that is handling all of the property and that is going to be in trust for that individual with special needs. So what happens when the child attains majority age? And now they're 18, or in some states 19, or in other states 21. At that point, you are no longer legally their guardian. And as such, one of two things needs to occur. If the child, even though they have a disability, has capacity to understand legal documents, then we very likely want the child to implement a power of attorney and living will or healthcare directive, in many instances nominating their parents or guardians and potentially successors as siblings as their agent under power of attorney. That's the person who is responsible for making the day-to-day decisions for an individual, usually called an agent. Many of my clients will come to me and say, well, I'm not really sure if they completely understand the documents. You don't have to make that decision. Go to the primary care physician, the neurologist, the psychiatrist, another person with a medical background that has examined your child, ideally for a long period of time, but it can be a one-off type of decision, and ask that medical provider to opine as to whether they feel that your child possesses the requisite capacity to sign a legal document. And I have seen that written on prescription pads by doctors. It doesn't need to be fancy. I examined X on Y date, and I feel they have capacity to sign legal documents. Generally, in an ideal scenario, you will have something a little bit more formal, and it can just be a couple of sentences on letterhead from that doctor opining as to whether there is capacity. If it is either clear that they do not have capacity or a doctor opines that they lack capacity, then you want to, at that point, commence a guardianship proceeding. Again, in some states, it may be a conservatorship, but generally it'll be a guardianship proceeding right after they have attained majority age. As recently working in a scenario where a child had a significant issue, health issue, and they went into a medical facility and they had just recently attained majority age, 18, and the doctors and the other providers could not legally provide any information. They weren't even comfortable with the parent in the room with them because of HIPAA issues. They were very concerned. So as soon as a child attains majority age, you need to commence a guardianship proceeding. That varies from state to state, that process. I've handled them in a number of different states, and I can attest that there is a very, very broad way of handling a guardianship proceeding. Different courts, different systems, different types of documents need to be prepared, different requirements in terms of some states may require one doctor and other states may require two doctors to opine. Some have a whole board. Most states will require a lawyer to be appointed for the proposed guardian, known as a ward, W-A-R-D, a ward. It's a person that is alleged to be incapacitated. And they need to have their own, not only doctors examining them, but a lawyer that is representing their interests. And then another key question that I would recommend to all of you to ask your attorney or whoever is assisting you with that guardianship proceeding is whether you can nominate a successor guardian. In some states you can, in other states you can't. Some states it's known as a standby guardian. So if you nominate, let's say my son Josh is 18 years of age in the future, and he nominates myself and my wife as the guardians. Well, what happens if both of us pass away? Now nobody is there and there's going to be a lapse or a gap and nobody would be able to assist him. And depending upon that child's severity of disability, that may be a significant issue. And in a lot of states, they will allow a standby or successor guardian to be appointed at that time so that if the primary guardian is unable to serve, maybe they just have a severe medical issue, but they're still alive, or maybe they have dementia in the future and can no longer serve, there is immediately somebody else who can step in without a gap in the guardianship. So something to keep in mind and something I would recommend that you ask of either the court or of an attorney as you are going through that process. For many other clients, let's say that you have maybe a child with a disability and you have another child or children who are not disabled. For those, this is just an aside, that are not disabled, but maybe they're going off to college at age 18. I very much recommend that they still sign a power of attorney and or living will and healthcare directive so that if there is an emergent situation or something arises primarily with healthcare, you will have this power of attorney that a child has signed in favor of parents to be able to jump in and assist and consult with medical professionals. So just something to keep in mind in that regard. Any questions on that? While I take a sip of water. Okay,
Sorry, I have a
please go
question.
ahead, Sarah.
Um, I hope this doesn't sound ignorant, but I have to ask.
Fun.
So a guardianship proceeding, and maybe this is different state by state, like, is that where you're going into a court, standing before a judge and having these documents created, signed by a judge? Is that what that means?
Generally, in some instances, I'm going through one right now in Georgia where they don't like the fanfare of it. And the judge, and it could be at a county level too. So each county may do things differently. But this county, the judge will have you sit in a room, basically the judge's office, as opposed to in open court. And it's a little bit more of a private setting. But generally, Sarah, you prepare a petition. There's a packet of documents. Many times they're on the county or state's website as to what documents need to be prepared. You fill those out. It's usually accompanied by at least one or two medical professionals' opinions who have examined the proposed child with disabilities, again known as a ward. And then you submit them to the court. And then often a clerk or somebody else within the court system will review them and then set a hearing. During the hearing, there may be a panel. There may be others who are going to make some decisions. And usually the ward, the proposed ward, will be accompanied by an attorney, and then you, the parent, would be accompanied by an attorney. And then the judge would determine whether that proposed ward is unable to manage their day-to-day affairs, financially, healthcare, etc. And if they meet that standard, and it is a little bit of a different standard state to state, then the judge is going to sign this piece of paper, usually called an order, that states that I hereby appoint this person as guardian of this individual. And then you will hold a piece of paper that you can bring wherever you need it, whether it's a doctor's appointment or whether there's some emergency and the police are there and they're questioning somebody about something, been dealt with that before. Any number of scenarios, you will have this piece of paper appointing you as a guardian.
Okay, thank you. That makes a lot of sense.
Sure. Julie had a question that says, are there restrictions to the types of expenses that can be covered by a special needs trust? Which is a very good question. And the answer is yes. And that can vary very much, again, state by state, as well as at the federal level. So generally, what you want to do in most jurisdictions, the special needs trust will say that we are looking to supplement anything that government benefits are providing and not supplant. So supplement, but not supplant, meaning that if a child with disabilities is receiving certain benefits from any of these government agencies, they will continue to receive those benefits, and anything that is not being provided by those government benefits can be supplemented, meaning it can be provided by the trustee of the trust. So let's say that there are the child is in a certain group home and receiving clothing and food and water and everything that there is their essentials, but maybe they're something that they need. Maybe they're always cold and they need a heated blanket. I'm just picking a random example that came up a couple of months ago for a family of mine, client of mine. And that would be something that would be supplemental, that is provided to them for their care, their general welfare, and will enhance their enjoyment of life, that type of thing. That would be a supplemental item. In many states, you can provide for travel. Maybe they need a car to be transported from place to place. Maybe it's a special van. Maybe it's handicap accessible with a wheelchair access, whatever the case may be, that may be a permitted expenditure. Sometimes vacations in many other states are permitted, and you can provide for a caretaker to take that person, and maybe somebody can accompany that person. Maybe there's specific dietary restrictions based on their disability, and they can only eat certain things, and it's not provided by the place where they are receiving government benefits. You can supplement it by providing those additional foods and snacks and whatever it may be. Maybe they enjoy certain types of entertainment. It can be a television, it can be a magazine subscription. There are a body of laws that have been established as to what is a permissible expenditure from a special needs trust that varies from state to state. Good question, Julie. Does that answer your question? Just let me know if it doesn't. You can shout at me here.
She gave a thumbs up, so I think it's a good
Perfect.
answer. Thanks, Mike.
Okay, good. So that covers guardianships. There are a couple of other items that I want to bring to your attention, one being retirement accounts. retirement accounts can be tricky for day-to-day estate planning. There is something called the SECURE Act, SECURE, Setting Every Community Up for Retirement Enhancement Act, that was enacted into federal law about 6 years ago, I want to say, and it overhauled how distributions are made and calculated from retirement accounts. So one planning suggestion that I make to a lot of families with children of special needs is that those that have retirement accounts may want to consider leaving retirement accounts to a child with special needs and then potentially receiving other assets, maybe real estate, bank accounts, etc., to a child who does not have special needs and a disability. The reason is that those that have a disability, a qualified disability, are able to essentially stretch the distributions from a retirement account over their life expectancy, which is a table that is promulgated. It is provided by the IRS to establish what a life expectancy is. And so there are significant benefits from a tax perspective for a child with special needs to be able to defer receiving these distributions and not have to pay the taxes. Whereas generally, there's a lot of complexities to it. A child who does not have disabilities will usually have to withdraw the funds and pay the taxes within most cases 10 years. Sometimes it's even shorter, it's 5 years. And for those that are younger, it may be 10 years after attaining majority age that they have to withdraw the funds. So a common planning technique that a day-to-day person who just writes wills and doesn't necessarily have a complete practice devoted to special needs planning may not know about. You may want to bring this to your attorney or other person who's assisting you in setting up a plan's attention. So a key point of planning to try to recommend at least have the discussion, because you always have to be your own advocate in everything, medically, legally, etc. Nobody's ever going to look out for you better than yourself, of raising these issues of retirement accounts. It comes up quite a bit in planning. In addition to that, I want to discuss 529 accounts and ABLE accounts because it comes up quite a bit. Fortunately, through some advocacy of our foundation and other organizations, we were able to cause Bainbridge-Roper syndrome, ASXL3, to qualify for Social Security Administration's Compassionate Allowance Program. And we are continuing to lobby and hope to have ASXL 1 and 2 added to that list in the very near future. But because of that and those efforts, it makes it a little bit easier to qualify for benefits, and improving that you have this qualified disability to be able to stretch these distributions over a lifetime. It will be easier now that we have this. And so I wanted to tie that in, and that's why I was addressing the retirement accounts to an extent. With 529 accounts and ABLE accounts, achieving a better life expectancy, that's an ABLE account. There are a lot of benefits to establishing an ABLE account because it doesn't need to be used. The funds don't need to be used by the beneficiary for strictly educational purposes. So it's a little bit broader. However, it will start to count toward your assets for calculating SSI, supplemental security income, over $100,000. Many families, that's or near an issue. For other families, it's a significant issue. So as I mentioned, I'm trying to cast a broad net here. So if you are contributing funds on a regular basis, maybe over the years, you're putting in just a couple $1,000s, few $1,000s a year, and then suddenly, after many years, you have over $100,000, it's been growing and earning income, it's being invested. That can create an issue if you're now contributing additional funds beyond that amount for SSI. For 529 accounts, you can roll funds into a ABLE account from there, but that's not always the best way to go. So if you haven't set one up yet, there is no 529 account in place, and you have a child with a disability, you likely want to establish a ABLE account. If you've already established a 529 account and now you have subsequently determined that there is a disability and you're considering whether you should roll over the funds, I'd recommend consult with an attorney as to your specific situation. That's one where, depending upon your assets and your scenario, you may be best off retaining the funds in that 529 account, but there are circumstances where it may be best to start rolling the funds into a ABLE account. There are maximum amounts that you can roll over. It's based on the exemption amount, the annual exclusion amount, which this year is $19,000. It goes up most years. It was 18,000 last year. It was 19,000 this year. It'll probably go up to maybe 20,000 next year. It's indexed for inflation. So keep that in mind as you are initially building out your plan for a child with a disability, and consider including an ABLE account within that plan. In addition to the maximum amount that you can contribute, the $19,000 to an ABLE account, and each state is a little bit different, a child can also contribute funds. So as I was talking about in my example, let's say Josh gets a job and is earning income on his own, he would be able to contribute those funds potentially to an ABLE account. It is not usually, in terms of a trust versus an ABLE account, one or the other. They often work very well together. And that's part of that plan that you're going to build out and tailor to your specific situation. I've been talking for a while now, so I don't want to overwhelm anybody, but my parting thoughts are that it is very important from a practical perspective to write out what you envision occurring after you pass away. It's a difficult thing to do. And for a lot of families with children without special needs, they don't do that. But for those that have children with special needs, this is the practical side of me speaking as opposed to the legal side. I handle a lot of probate after somebody has passed away. And for even those without special needs children, it is a very difficult process. So you want to try to have everything as organized as possible anyway, listing out all of your assets, all of your debts. But to take it one step further, those that have a child or they're a caretaker for somebody with a disability, it's so much more important to have that letter. A lot of attorneys and others will refer to it as a letter of intent. I usually just kind of call it a letter, and you outline exactly what you recommend to occur. I live in the same household with my wife and my son and my daughter, and I am very, very involved in my son's life, and even me being under the same roof. If my wife were to pass away tomorrow, I'd be pretty lost. And I'm right under the same roof. So I can only imagine what it would be like for others, my parents, my wife's parents, and siblings, and others that are going to have to jump in there if I don't have a complete understanding of his schedule and medications and all the other things that my wife does day to day that I try to follow, but only to an extent, then others are not going to be able to do so. So play it out, whether it's you individually or you have a spouse or another parent of that child, sit down together if at all possible, and not only outline who all the doctors are and who the therapists are and what their schedules are and what the medications are. And I know that's a challenge because it can fluctuate. But if you have the core of it in terms of day to day and who the first person should be for them to call that will be able to start piecing this together, that will go a long way. From there, you should also outline any rituals and routines and things that are going to be important to the person or people that are caring for your child. And I understand as well as most with how much this fluctuates, because Josh changes on an hourly basis. Forget day to day, month to month, or year to year. Things can change in literally an hourly basis. But there are certain core things. his therapists, his doctors, his medications, and who to call and where to go and all of that, that can really, really help people. So I would strongly recommend that you carve out just 30 minutes, 60 minutes, sit down with, either on your own or with a partner, and map that out and put it somewhere where somebody can find it. Oftentimes that copy will go to the lawyer. A lot of times people have a safe deposit box, others have a safe in their home, maybe they have a file cabinet, but put it somewhere that it can be found relatively quickly after you've passed away. Question just came in from Julian. It says, how often do you recommend that we revisit the SNT, a special needs trust, once it is established? This is a good question and an important one to address because in many instances, Julie, you can't revisit it. So it will depend upon whether it is revocable or irrevocable. If it's irrevocable, you can no longer change the terms. But during your lifetime, I often will recommend that it is revocable. So I generally will say every maybe 2, 3, 4, 5 years, revisit the documents, but particularly if there is a significant life event. If a family member that you have nominated as a trustee has passed away or has dementia or is becoming ill or just elderly and there's some concern there, at that point, you want to update the trust if you are able to do so. If another beneficiary, let's say you've nominated other children as remainder beneficiaries and they've passed away, that would be a time to update it. So most special needs trusts are going to last a long time without needing to be revised. So even if they're revocable, the language in them doesn't change a whole lot. It's more that for the child, it's more that you're going to need to update them with a significant life event of a trustee passing away or becoming disabled, or a contingent beneficiary passing away or potentially becoming disabled. So those are the factors that I would generally look toward, as opposed to a day-to-day will or trust where a client says, I just don't trust my child. I know I had in there leaving them everything at 25. Well, now they're 25 and they definitely are not mature enough. So they call me to update the documents. Those types of things are different from a special needs trust because it's for their lifetime. A special needs trust is for their lifetime. And those terms, unless the law substantially changes, are not going to really be impacted. If your lawyer or accountant or somebody else in the inner circle that you rely upon for updates on changes in the laws, they have a listserv or something like that, sign up. I am subscribed for almost everything except for, of course, the ARRE Foundation emails. I just get too many emails, but if you have somebody like that that provides updates, I know we as a firm, the firm I work with that employs me, will send updates if there's any substantial changes in the laws, either in your home state or federally, that may impact or necessitate a change. So I'd encourage you to take advantage of that and sign up so that you receive those updates. And that would be a good time, opportune time to update documents if you're able to do so. Amanda, Sarah, anything that either of you want to add? I could go for another hour here, but I'm not going to do that to everybody. We'll save it for another time. I'm more than happy to address questions now or afterward.
Yeah, I think we'll just do one last shout out if anyone has any other questions or, you know, thoughts that they wanted to share with Mike.
Try to find a group of professionals that truly have experience with special needs. Attorneys are probably a little bit easier because there are a decent amount of attorneys in each state that have special needs trust planning experience. In limited circumstances, if you're fortunate enough, you'll find an accountant that specializes in special needs planning. And then in other instances, you can also find financial advisors that cater to special needs matters and families with special needs. But the real key is to try to at least have one person in that circle that does so. And the other parting word will be to put a strong emphasis on the trustees of these trusts, because you're not going to be around forever. You are likely going to outlive your child. And if you even name a person that's a little bit younger than you, they may very well pass away before a child. So start thinking through who may be the successor guardians and trustees in these documents.
Well, thank you so much, Mike, for your time and just sharing your expertise with us. This has been so helpful and very informative. And Nicole, did you have a question?
No, I was just going to say that this was really great. And I have a whole checklist of things to do on my phone. We do have all the paperwork, but we did it like 10 years ago and it needs to be redone. And we need to hire somebody that's more specialized in special needs planning. And I have a 30-year-old stepdaughter, and I was with her earlier, and I said, yeah, you're not even getting your money yet. You're still in a trust. So we have to like change all of that. But I have a great list here. So
Excellent.
thank you.
My pleasure, Nicole. Thanks for joining tonight.
So I did think of one question, Mike. Is there
Sure.
if people are looking just to sort of learn a little bit more about this, is there a particular like state agency or department that you would recommend that they look at, or like an association of special needs attorneys? Like, are there sort of like higher level entities that you could give people sort of a Google head start on if they wanted to look up a little bit more about any of these topics that we've covered?
Not at the state level, Amanda. I don't think there's necessarily anything that I know of where every state has this type of department and they put out those resources. I'm sure some states have more of that than others. There is the special, I think it's called the Special Needs Alliance, that puts out very good articles. I can look it up and we can send it out afterward. I think that's what it's called. I've been impressed over the years with their literature. I find that their articles are very well written, informative, and researched, and they keep up to date. So as there are changes in laws, they will usually post or publish articles about it. So I'd say that would be a good place to look as well.
Thanks.
Sure. I also want to just make a final comment that appreciate everything Amanda does. I will echo very much what Sarah said. She is a rock star to our organization and works tirelessly with very little support and assistance. So thank you for everything you do, Amanda. We very much appreciate it. And of course, you as well, Sarah. Thanks for putting this together.
Yeah,
Of course.
absolutely. My pleasure. Yeah.
All right.
All right. Well, if there's not anything else, I think we'll wrap up our time together. And we I just appreciate everyone being here tonight. Thanks so much for joining us. And one last huge thank you to Mike.
Yay, thanks.
And everybody have a
Thank you.
great night.
Good night, everyone.